So the implications of his court case were very large. So this court case expanded the Fourth Amendment protections dramatically, from basic search and seizure to any concealed information, even public information, as long as it's concealed. The the argument is that if the suspect exhibited an expectation of privacy, subjective expectation of privacy, even if it's in a public space, and if society at large would agree to such an expectation, this is something called Katz law. So from Katz versus the United States, there was formed a thing called Katz law, which is if the person exhibited an expectation of privacy subjectively, and then if the objectively, if the larger society would agree to that expectation of privacy, then it's unlawful to search and seize that, or that is protected, I suppose, unless there was an actual warrant. The point is that the FBI did not search and did not have a warrant to do this. But I guess a good example, to stay on Katz law for the moment, a good example of Katz's law is, for instance, your Fourth Amendment rights are protecting you from anybody from law coming in and seizing documents or any other kinds of evidence from within your house, from which subjective levels of privacy are there. You know, if it's reasonable to assume that papers in a desk in your house are, I believe Katz's law would say that it is subjectively, there's a subjective expectation of privacy on the individual level, and there's an objective level of expectation of privacy on the societal level. So that's Katz's law. And but for instance, if you had something in your window, or somebody saw you commit a crime from viewing you from your window outside, then that is not Katz's law, because because the individual may think that they're in a private space, but society at large would say, well, if I'm walking by this large bay window and I see somebody commit a crime inside of their own home from outside, I can see through their window. That's not really, that's not an objective expectation of privacy. So, and this Katz's law was used in another case called Smith versus Maryland in 1979. So this Katz's law has been used in other court cases, but that would distract from the larger point here. And another thing worth mentioning is that Katz's law overturned another law called, or another previous ruling by the court, saying it's called Olmstead versus the United States in 1928. And this Olmstead versus the United States ruled that federal wiretapping was not a violation of constitutional rights. So federal wiretapping up until Katz versus the United States was not there was no Fourth Amendment protection against federal wiretapping. I assume without a court ruling, or without a warrant. So, and that's what this is really all about, is whether or not there was a warrant granted, because the FBI wants to gather evidence without enough. So the FBI knows that there's not enough evidence of a crime in order to receive a search warrant from a judge, but they want to go ahead and gather their own evidence regardless. So they go and collect information without a search warrant. So wiretapping by the FBI without a search warrant was permitted via the ruling of Olmstead versus United States from 1928, until Charles Katz versus the United States overturned that in 1967. So, and then of course, like I said, the Katz law has been used in other cases, and of course this is all a rather, somewhat outdated. Well, it's an important. It was a landmark decision, But you know, we live in the world of the Patriot Act, and that has since rendered this irrelevant ostensibly irrelevant. So, but you know, it's still an important legacy ruling by the Supreme Court, and goes to show you, well, in the case of the phone booth, the payphone, it's in a public space, but there's a reasonable expectation of privacy within that phone booth, and just because it's in a public space does not mean that you're not having a private conversation, and that most of society would agree that you're having a private conversation. So, and there's that subjective and objective expectation of privacy, which is important to recognize here. So, anyway, I wanted to share that case with you guys. I hope you find that interesting, and this opens up a variety of other court cases relating to free speech and protection of privacy that are certainly worth looking into going forward. So I'm going to look into those as well and share them with you. So anyway, thank you guys.